Yes.
or not responding.
Yes.
I've already made my address to you.
Yes.
But there are issues that Mr. Kaluma has raised.
What is the issue?
The issue that Mr. Kaluma has raised is one, what he says about the right to life. He is putting it that it is the first one that is addressed by the Constitution.
Bill of Rights. Bill of Rights.
In the Bill of Rights.
Yes.
The Bill of Rights is in the Constitution.
Yes.
My Lord, we want to say something about that.
Okay. Proceed.
Then number two, my Lord.
Proceed.
Mr. Abisai will address you on that issue.
I thought you were the one responding.
Very well, my Lord. It could very well be that the right of life is also covered by the Constitution. But there is no right which is superior, and there is no fundamental right which is inferior to the other. Both of them, in my submission, have an equal status in the Constitution. If Parliament intended to say that the right of life is primary, or to life is primary, it would have employed words in the same Constitution saying that the other fundamental rights in the Constitution are subordinate to the right to life. Number two, my Lord, I do not know how Mr. Kaluma can make a submission that this is a complex investigation. That is something that Mr. Mbani should have mentioned to us, not Mr. Kaluma. And again, when he says that without placing before court through an affidavit of such complexity, and that affidavit must be sworn by an officer who is investigating this crime. I think for now that is all I would have to say.
Yes, Mr. Imbali.
Yes, Lord, I'll try to address the issues raised by my learned seniors.
Yes.
One, what was before Homa Bay in court was a miscellaneous application. A miscellaneous application which was very clear. We only required 14 days to enable the investigators to conduct proper investigations. We are very much aware that murder trials can only be tried by the High Court. And Your Honor, my Lord, the reason why we took the suspect at Migori, at Homa Bay law courts is because we believe in the rule of law. The only way we could have held the suspect lawfully is by having the suspect arraigned before court, and court grants us the orders. My Lord, my learned senior has also highlighted contents of number 3 of the said order, which reads, at the time the said suspect be presented before the judge for plea or other orders. That is why we are here. And these other orders we're seeking for are very simple. Sticking to what we were requesting at the lower court, that we need sufficient time to conduct proper investigations.
Yes.
My Lord, I wouldn't want to insinuate that my senior is lying, but the power of the DPP is exercised out of his own delegation. And in this matter, so far as it stands, it is myself and my two colleagues who have been tasked to prosecute this case. I agree that Mr. Loch, my senior, is the in charge of Homa Bay County. But if council thought it wise to consult him, that was a matter of choice. And let the record be very clear, my Lord, that at no point did I tell my senior I was on my way to Nairobi. He did call me, I accept, and I told him I'll call him back. Your Honor, I believe it's a senior Amolo who has alluded to the fact that the situation on the ground was so hostile
Yes.
that they had to be escorted by armed officers out of Homa Bay. That is the truth. That is the truth. And that is one of the grounds why we are telling the court that indeed it is true that the only way this matter could be fair, impartial, and probably cooled down the temperature a bit, in fact, for the benefit of the suspect, this is the right jurisdiction.
Yes.
Your Honor, it is not true. I don't know how they are computing their timings. According to their computation, I believe that was my senior again, Madam Ashoya, who said that so far we have spent 7 days. As far as we are concerned, we went to court. We were only given 3 days. And again, because we believe in the rule of law, we went back to the same court. And it gave directives that we appear before a judge. And the orders are not even specific. A judge at 9 a.m. Failure to do that, the accused person, the suspect stands as is released from custody. We rearrested the accused person. We rearrested the suspect yesterday at 9:40, and this morning we are before you. It is therefore our submission that at no point was the suspect held unlawfully, and in fact this is in compliance with the court's directives. My Lord, it is also a submission that indeed this is a complex matter. It is a complex matter where, as I say, to reiterate, the investigators have several gadgets that they need to examine forensically to establish and tie up our case. In fact, what the DCI did in his own wisdom, he dispatched the homicide section within Nairobi, a section that strictly deals with complex murder cases, to go on the ground for two reasons. One, to try and expedite the investigations, because obviously we will have many hands. And two, to ensure that the process is impartial and fair, conducted in a professional manner, to avoid insinuations and doubts. Your Honor, they have mentioned Article 49, 1A of the Constitution, and to be precise, sub-articles G and H. My Lord, we have been in compliance with the law from day one. And why do I say that? The suspect has constantly been informed why he is being held. In the said affidavit of Koklo Hassan that was filed at Homa Bay, it is very clear that he is a suspect in a murder case. Your Honor, when I started addressing you, I was very categorical that we do not intend to take plea today, but we are kindly requesting the court for the particulars to be read to the suspect so that he is aware for what reason he is being investigated. Your Honor, on the second issue that counsel raised, in my opinion, was to do with bail. We can only oppose after bail has been sought after. It is not for us to come and tell you, for this and these reasons, don't do this and that. It is incumbent upon counsel to ask for bail. And the bail issue, my colleague will address that. Your Honor, about these treatment issues of the accused person, there is nothing further from the truth. It will be their word against our word, and that's why I'm avoiding to go that direction. As I've mentioned, the people who are taking lead in this matter are the homicide section, which are based here. They are trained to do that. And in fact, when they say he was in Kisumu, we have been in constant liaison with the head of the team, Mr. Martin Mibuto, and he told me the reason why they only went via Kisumu because he was en route to Nairobi. So if counsel submits that the client sat the whole day and they were in a car, I don't know how he expected the client to get here. He had to sit down. But I've confirmed from them, he had his meals. In fact, they ate together. And he also had his drinks. And every time he needed to relieve himself, he was allowed to do so. Your Honor, my Lord, they raised an issue of their clients having been taken from Homa Bay Police Station to Oyugis. Your Honor, I didn't want to look at the contents of the previous orders given by the magistrate, but order number 1 was that it should be within Homa Bay County and to enable police conduct the investigations. There was no other reason why their client was being moved from Homa Bay to Oyugis, which, for your information, is still within Homa Bay County, was for purposes of investigation, which...
My Lord, counsel is not reading the order with the fidelity that is required to be read. The order, my Lord, is very clear. The suspect, Michael Juma Oyamo, be held in custody of OCS Homa Bay. I shall not be moved to any other place without the order of this court. Now he's introducing that my client was lawfully being removed from Homa Bay Police Station to Oyugis because they're in the same county. He should be honest and forthright with what the court said. Okay. My Lord, I must make that objection at this point.
Okay, proceed.
And continue with my submissions. My Lord, he was moved to Homa Bay.
To Oyugis.
Oyugis, sorry. My Lord, with the knowledge of the court. I want counsel to give me a contrary response.
My Lord, again, I must come to the aid of the court. The DCI, Homa Bay, was invited to address the court on Monday.
Yes.
And he admitted that the day they moved Michael from Homa Bay to Yugis,
Yes.
the court was in session, but they never went to that court to seek any order. So when he says that the court was aware, it is for him, because he's alleging, to make that material available by way of a court order or court proceedings, that the court is aware. He cannot push it back to us now.
Yes. Mr. Mbali addressed me on other issues. Leave that issue. I'll rule on it. Yes. Yes.
My Lord, we also submit that our reason for requesting for extension of time is because we have other suspects who might also be culpable or accomplices in this matter. Again, it is therefore not factual for counsel to allege that it is only the suspect that is or has appeared before court and is in custody. We have another suspect, and we have the misdemeanor application, where the suspect was arraigned before Kisi law courts, and we sought time to have him detained for 13 days, application which was granted.
Yes.
My Lord, with all the obstacles, we managed to get the statement of the accused person on Sunday. And while at Homa Bay Law Courts, we pleaded with the magistrate because the investigators, after he gave his own statement, my Lord, which was in the presence of his counsel, also gave fresh leads on how the investigators need to pursue the matter. And we are saying before you, my Lord, we do not have sacred cows in this case. Honorable Kanuma, who is watching Brave from the family, is the area MP. And not just him representing the people of Homa Bay, including everyone. The country is pregnant, awaiting to see who the suspects are, and we are making our undertakings. Once we finish our investigations, everyone will be subjected to the same treatment. And finally, my Lord, if I may borrow my senior submissions,
Yes.
that all constitutional provisions stand the same footing, I wish they became just a little bit more diligent. Instead of just confining on Article 25 of the Constitution, just proceed one more article, Article 26, clearly stipulates the right to life. And Your Honor, that is why we are here. And we are saying it is not our wish for the suspect to be in this kind of situation, but the public have taken great exception on how the victim herein was tortured and brutally murdered, and want the culprits to be brought to book. And that will only happen if we have conclusive and thorough investigations. I'll let let me proceed on the issue.
It's okay. It's okay. It's okay. It's okay. Okay, this is my ruling. You may stand. The issue before this court is rather straightforward. Has the prosecution laid sufficient basis for this court to order for the subject to be detained for a further 14 days? As I get it, the prosecution is saying that the investigations being undertaken by the police is multifaceted and involves many leads and suspects, both in custody and at large. There is forensic material to be examined and processed. There is also the element of public interest, which must be taken into account by this court. The defense team is of the view that the continued detention of the subject is unjustified in view of the period of 7 days that he has been in police custody. They are of the view that the police have had sufficient time to process the subject. They have also complained of the subject's alleged mistreatment while in police custody and further pointed out the breach of the initial court order issued by the Chief Magistrate's Court at Homa Bay. The family of the deceased's interest is that justice must not only be done but must be seen to be done. They want to know the truth, and the truth will be established why their daughter and her unborn child were tragically killed. The first issue that this court will address is on the question of its jurisdiction. This court has jurisdiction to deal with the matter that this court has been addressed. I did not hear the defense counsel to question the court's jurisdiction on the merits of the application, to question the court's jurisdiction. On the merits of the application, this court agrees with the prosecution that due to the multifaceted and complex nature of the investigation that involves many suspects and many leads, it is only fair that the subject continues to be detained for a further period of 14 days. He shall be detained at Muthaiga Police Station. During his detention, his rights and fundamental freedoms that are guaranteed by the Constitution shall be protected. He shall be allowed access to his counsel during daytime. His relatives, who shall be vetted, shall also be granted access to see him. He shall be brought to court after the expiry of 14 days, where the prosecution shall be required to have him formally charged, or he shall be released. Pursuant to Article 49(1)(g) of the Constitution, this court shall read the charge to the subject, but he shall not be required to plead to the same. The purpose of reading the charge is so as to notify or put the subject on notice of the charge that he is likely to face. The subject shall be at liberty to apply, pursuant to Article 49, Subarticle 1(h) of the Constitution, upon expiry of 14 days to be released on bail if the prosecution decides to charge him. The court has desisted from rendering or making any comments in respect of what transpired from the day the subject was arrested to today when the subject was arraigned before this court, because it may form the defense of the subject. If he is tried, the defense of the subject if he is tried, it is only the trial court that has jurisdiction to address the matter. The defense counsel are at liberty to raise the issue before the trial court. Those are the orders of this court. So I'll formally read the charge to the subject, but he shall not be required to plead to them. It's just to put him on notice. Okay? So your name is Michael Juma Oyamo. Do I read the charge in Kiswahili or in English? In English. Okay. You have been charged. This is the information which has been brought before us, but it is not a formal charge which you are required to plead. It's just to notify you. And this is the information. The information says that you shall be charged, or you may be charged with murder contrary to Section 203 as read with Section 204 of the Penal Code of the Laws of Kenya. And the particulars of the offense are that between 3rd and 4th September 2018 at Owande area, Rachonyo, South Sub-County within Homa Bay County, jointly with others not before court, you murdered Sharon Otieno. So that is for your information, and you'll be called upon to answer to it, or if investigation establishes that you are not involved, you shall be released. You may not be required to plead to that charge. So it's just to give you informed so that you are aware of the charge that is likely to face you. Your defense counsel will be on notice so that they can prepare your defense if you will be charged. But if you are not to be charged, you will be brought before this court within 14 days. The 14th day is which day? And then I'll give it, you will appear before the trial court. Myself, I'm in the criminal appeals section of the High Court. So you will appear before Lady Justice Lesit, who is the head of the murder section, for the purposes of mention and, if possible, the taking of plea. Which is the 14th day? Yes, the 14th day is on 25th of, okay. So 25th. 12 plus 14, 26. 26 is which day of the week? Okay. Mention on 26th of September 2018 before Lady Justice Lesit. Sit for further orders. Okay. Next.
Application number 524-2015, David Melo.
Who is in this one? Yes.
I hold comments for the respondent state.
Who is for the applicant? Andolo. Yes. What is the position?
The position is that significant offenses